Hi, everyone. Good evening. Carl Steinbeck here. Welcome. Tonight, I'm going to cover reasonable doubts number 41 to 60 for Massachusetts versus Karen Reed. These are AI created ones that have been modified because the AI ones had some issues with them. Some were not exactly correct. So these are actually improved over AI. And there's always improvement they could even have from these as well. Let me go ahead and present. Let's see here. So we covered initially the investigation irregularities 1 to 20. Those could be added upon as well, easily more than that. Then last time we covered this, the forensic evidence doubts 21 to 40. There's definitely more that could be covered there as well. Tonight we're going to cover witness testimony issues 41 to 60. And there could be much more spoken about here as well. So as you can see, there's many factors that the jury should consider, and they will consider, and they must consider in finding that the state has not proven their case beyond reasonable doubt. So a jury can think that Karen Reed is guilty, but that's not enough. A feeling is not evidence. A feeling is nothing but a feeling. What they have to have as a prosecutor is evidence that's compelling enough for the jury to really believe and feel convinced that there is really no reasonable doubt other than the fact that the defendant is guilty, and they're just not even coming close to that standard on this case. So these are the kind of things that I expect the defense to be hitting home in their closing. Their closing is very short, and as I've said, it only takes one reasonable doubt. It doesn't take 2, 3, 5, or 10 reasonable doubts. If there is a reasonable doubt, the jury must acquit. So with that, let's go ahead and proceed to number 41. And that is Jen McCabe's conflicting statements about Karen Reed's words. All right, as we recall, the testimony from Jen McCabe in trial 1 was talking about how Jen was saying, I hit him, oh my gosh, I hit him, and making all these incriminating type of statements. But yet, as it was brought out through cross-examination by Ellen Jackson, she never said that one time in her previous testimonies, multiple testimonies beforehand. Nor did she say that to any investigator, Trooper Proctor specifically as well. So this is something that she did to enhance her testimony. She's piling on against Karen, and her memory doesn't get better over time. Anybody's memory is going to get worse over time. So she never thought of saying those kind of comments before. And so the question is her memory better when she testified trial 1, or was it better a couple years prior when the incident happened and she had firsthand near same day type of recall to describe when it was initially described to her statements and Trooper Proctor that none of those words came out, none of those incriminating type words came out. And I submit to you that even if she would have said, I hit him, like she was told that different things by Jen McCabe that hasn't probably all come out. But what was Jen McCabe saying to her to make her feel like she might have been guilty? So, and if you think you might have been involved in something, it's involving the significant injury or death of a loved one, you automatically feel guilt. I mean, the guilt and shame that you would feel, and I'm sure she felt initially. And then you had also law enforcement saying that this was they had video proof of Jen doing it, so she must have felt guilty in the initial stages. But you know what? She never said that. She never said that in the initial minutes there, and the delay until John was carried away in the ambulance about anything about her being the cause of this. So Jen McCabe's testimony is really suspect. It's very much, like I say, a pile-on effect, and that kind of thing should not be considered credible. And so it actually brings more suspicion upon Jen McCabe. So every time Jen McCabe doesn't say something that appears truthful, it actually makes her look more suspicious. So ask yourself, why would Jen McCabe have behavior that's not consistent with somebody that has nothing to hide? If you don't have anything to hide, you don't have to worry about filling all the details. You're not going to have testimony that doesn't square with the different forensic data that reveals different behavior that you perform. So with that, Yeah. Let's see. Chatterbox, you're saying if you have any questions, go ahead. I'll take them now as well as we're going through here. Chattermax is saying hit on its own doesn't even mean a car. Slap punch, and no one's asked her to clarify. It really didn't happen. And through the actual forensic physical evidence, we know that it was not her. She wasn't even there at the time. So it's abundantly clear something else happened aside from Karen being involved. She was not involved in striking John O'Keefe's body with her vehicle. That is abundantly clear. Okay, next we have 42 is Jen McCabe's Google search for how long it does it to die in the cold at 2:27 a.m. So there is some discrepancy on whether this was confirmed or not through an expert witness of the state, but I believe that this is not correct. I think around the 227 timeframe was too much coinciding with other moving parts going on. That seems to make the most sense. And this is something that keep in mind it was around the time frame that Jen McCabe was desperately looking outside to see what the status of John O'Keefe was, and she was seeking his whereabouts up until 12:50 that night. So those are the kind of things that are just highly suspicious. Why would she be Googling searching this if nothing had happened at before that time frame? Her testimony is that this is something that Karen was telling her to look up, but I think the evidence shows and will show to a jury that there's just too many suspicious mannerisms and statements that are not credible at Jen McCabe. That this is reasonable doubt right there. No matter what you really believe, digitally there is a suspicion there, and I think it's a well noted suspicion and a doubt that this Google search likely was done at 2:27 in the morning. And if it was done at 2:27 in the morning, then that means he was already out there beforehand, right? So next we have for 41, no witness saw Karen strike John O'Keefe's with her car. There's not a single eyewitness to that. There's no videotape testimony of that. And there's a lot of ring cameras along that road. There's nothing along that that was obtained by the police that indicate that she had anything to do with this. That alone can be reasonable. A lot of juries nowadays, they want to see CSI type of information. They want to see the digital type of evidence. And if you don't have it, that can in and of itself appear suspicious. You're telling me the police officer across the street, his wasn't working properly. You're telling me a first responder, a 30-year detective doesn't have any kind of setup like that either. It just doesn't make sense. If it doesn't make sense, there's reasonable doubt. And with that, we'll move on to the next. Number 44 at 12:21, John O'Keefe's Apple Health data showed 80 steps of movement, and he ascended 3 flights of stairs. Whether it's up or down, it doesn't distinguish that. But that is a huge issue that shows he must have been in some kind of dwelling. He must have been in a house. If it's a house that he's going up and down stairs, it's not the initial couple steps to go up inside a residence, but you're talking about floors. He's moving up and down floors of a residence. So if he's doing that at 12:21, what does that tell you? He got out of the car and got away from the car. So he didn't climb over the car. He didn't climb up on the luggage rack of the car. He didn't climb up a tree. He went into a house. So the question is, which house? So that is abundantly clear, and a jury's going to see through that. So with that kind of digital information, it really paints a bad picture of all the rest of the folks in the house. There's something very fishy about their testimony. When the digital evidence of this 12:21, then you square that also with Karen having been already at John O'Keefe's house at 12:36 and a 6-7 minute drive, even in good weather conditions. So it's basically pretty clear cut that's her alibi, and they can't prove that she was there. And John had movement. at 12:21 for about a minute and 15 seconds in that ballpark. So that's really helpful to her. And that those two data points alone shows a state that has no case. All right, next we have 45. Both Brian's guilty behavior and the discarding of their phones. These are law enforcement officers, mind you. They're discarding phones right before they're going to find out that there's going to be a search hold on these that's signed by the judge, a preservation order, and suddenly they ditch their phones and SIM cards. That is very incriminating. Like I say, no law enforcement officer would do that unless they had something to hide. So that begs the question, what do they got to hide? If they have nothing to do with John's injuries, and they don't know of any injuries that are caused by John, against John by somebody else. So if they know absolutely zero information, why would this happen? Is it really a coincidence? But in serious crimes, there's not a coincidence. Coincidences. These are indicators of something else going on, and these completely undercut and undermine the prosecution's theory. Think about all the different deceptions and misstatements that are spoken by the prosecution witnesses that are contradicted by the digital evidence. And what does the prosecution do? They just look the other way and just take these witnesses' words as if it's golden. A jury should not do that. The defense should really highlight these inconsistencies and talk about motives. Motives, from what I've seen in criminal cases, is absolute one of the main keys that I've seen. Here, we don't know the true motive for anybody to want to have John O'Keefe injured, but when you have somebody laying out in the street and all this testimony about people coming and going, people looking out the window for many minutes, and you have digital evidence showing he was going up and down flights of stairs, and you know that Karen Reed was not anywhere around that house from about the 12:29 to 12:30 mark, because she was at John's at 12:36. It leaves a very short window for him to have gone in the house and something happened within a matter of minutes, and then she left and she didn't know what was going on. So other people know what happened to John O'Keefe, but Karen will not be a party to know that. Okay, Kathy Prosser, you're saying you agree, and hopefully they'll use this a second time around. Oh, you're saying Glenda Carnes is saying defense should use this list as an outline for their opening. Yeah, I mean, you can just do like a search, have a search engine like Grok, GROK, and that'll give you this kind of information. But like I say, it's not 100% solution, but it's probably like about a 85% solution. JC's got a good question. If someone is stepping outside carrying John, would the steps register on the health data, digital evidence, or does it stop if you're not walking? I think it doesn't matter whether you're walking or being carried or dragged. I think it just is tracking you in relation to GPS coordinates. So, and how it's able to tell whether you go up or down. I think from that data, maybe that they're going by sensing steps or something. I don't know how that data works. So if somebody else could clarify that, that would be helpful for the defense as well to explain that in greater detail. May the force is saying, tell them the guy never went in the house. Yeah, that's what Matt McCabe had texted. So why would you say that if he never went in the house? That's a good indicator as well. And like I say, we don't have all these different witnesses in the house and all the inconsistencies and all the absolutely baffling stories that they're saying in court. So the McCabe's and the Alberts, they're just not making any sense at all. All right, so next we got 46 is a snowplow driver's, and that's his nickname's Lucky. Timeline contradicts a prosecution story. So the prosecution story is that John O'Keefe was laying there from 12:45 in the morning, and they sort of jumped around to say no, it was around 12:30 in the morning that John was struck by Karen's car. But the snowplow driver, it's pretty clear with his bright lights on that big vehicle, and he drove by right in front of 34 Fairview, and there was no vehicle there at the time when he made the first pass. When he came around, made a second pass, there's another vehicle there that wasn't there the first go around, and that was a Ford Edge. And so the timeline of when John was injured and laying there is not making any sense. This snowplow driver is one of the key things I find in criminal cases. You have some kind of like outlier witness that has no ties to any of the parties. Granted, this driver knows the Alberts, so if anything, you might think he's a little bit biased in favor of the Alberts, but he comes across as completely sincere and credible. And he's saying that there was not a body seen there, and in essence, he would have seen a body if there was one lying there. I remember some objections by Lally not wanting that to come out, that saying, would you have actually seen John O'Keefe who was laying there? The prosecution tried to keep that out. But like I say, the prosecution is doing a lot of keeping out the truth on this case, because that's what they're doing for their best efforts to get a conviction. Andrew D., you're saying the prosecution said Lucky changed his timeline, which he denies. Could the defense verify his timeline? Well, the thing is, they didn't take any statements from him. As I understand, the law enforcement never did. So, you think that's something they would seek out on their own. It wouldn't be defense having to hunt a witness like that down. They know the streets were plowed, but again, there was no effort to try to flesh out the details of what happened to John O'Keefe that night, because they already had it in the bag. They're going to blame Karen. I love Queen Ruthann. Lucky was one of the most honest witnesses, and tolling company treated him like garbage and said his story changed. It didn't. Too much to believe him, but their other witnesses were credible. Yeah, you're talking about the defense there. So yeah, you're not going to shake this guy. He's a very credible, ironclad type of witness. Al Dente, you're saying, so no one checked the backyard for footprints. Colin, in my opinion, left afterwards with the dog. That's what I'm seeing a lot on comments. Yep, they need to focus on the timeline. I agree with Cheryl Crawford, but they also need to present that in like exhibits to the jury in their arguments. Sidney Collin, you're saying that Commonwealth tried to hide Lucky from the defense. Queen Olive Ruthann is saying the Commonwealth only interviewed Lucky after Turtle Boy did. So that goes to tell you there how much they're trying to not build a proper investigation on what happened. And the thing is, the prosecution isn't even calling these witnesses. Why aren't they calling the snowplow driver? He's setting the scene on what happened that night. It doesn't fit their narrative. They only want to hear from any kind of evidence that fits their narrative, but their own witnesses contradicts the forensic details, the forensic evidence that just totally shows what a farce this prosecution is. Dip, you're saying Lackey's testimony was disregarded by jurors. Well, they better pick a better jury this time, because if they got somebody that checked out on this jury, it's really a sad state of America to have that kind of jury. I've never seen a jury that's this bad as what we've seen up there in Canton, Massachusetts. It's got to be the worst, probably the worst I've ever seen. Are you going to strike out twice in a row with this bad of a jury? You got a bad judge, you got a bad prosecutor, and you got a bad jury. You got all the facts that are actually showing that they can't prove your case for reasonable doubt, and you get a hung jury out of that. It's this absolute hot mess. Okay, next we have 47, Jen McCabe's repeated demands. Hold on, I can't read that. Repeated denials of forensically proven data. So she said that she never deleted those 6 messages. She's disputing the Google search timeline that showed 2:27 a.m. She's searching about how long it takes to die in the cold. So really, you got proof, digital proof that you deleted your messages. Why would you delete it? And even how long it takes to die in the cold, why would you delete that? If it really was Karen, why would you delete it? What do you got to hide? All right. Ipsy Dixit. Sherilyn, you're saying Bev dismissed several pro Karen jurors and appointed a cop as foreman. They stacked the deck against Karen. Yeah, so did this judge also on selecting who the alternates are and who the primary jurors are? She read off numbers, and I heard people saying there's no accountability for that because she could have picked the ones she thought were maybe likely to side with the defense, which is the attorney that's on the case there now, decided to help Karen out because she's so disgusted with the lack of integrity in the justice system. So, yeah, it's there's just so much there that can be rigged. It is very disturbing. That should be all out in the open. You shouldn't be doing that. And the judge picking the form and all that kind of stuff. I've never seen that before. But it's a good way to help control the outcome of a case. I'll tell you that. Yeah. How did John plan on getting home that night? I would say he never had a chance to think about that because something happened soon after he got there. He was with Karen, so they would have left together. Sidney Collin, you're saying the alternates were clearly pro Karen Read. So how would the judge know to get rid of those kind of pro Karen Read folks? And she picked the primaries before the alternates. Yeah. So this thing can be really skewed to which side you want to help to tip the scales towards. Okay. So next, it's not letting me remove a comment here. Okay. So now, next we have 48, Jen McCabe's close ties to the Albert family raised bias concerns. This was brought up by the defense counsel. She was her close ties of many years to the Alberts does show she treats them almost like family, almost considers like family, and her loyalty to them, as well as her husband's loyalty to them, is an issue that can be raised and should be raised by the defense because it shows they're joined at the hip. They don't want to have anything to hurt either party. So that's why they also were in group chats talking about how to get their arms around whatever information the police are investigating in that limited fashion. And they're keeping tabs on when people show up. Why is Brian Albert going to Jen McCabe's house? Why is Jen McCabe going to Sergeant Lanky, I believe the pronunciation is, his house the next morning? He was one of the investigators on this case initially. Why is she spending like 45 minutes to an hour there? So all this kind of stuff looks just very much as if you're trying to get a controlled script on what happened. And as Alessi's vocabulary points out, she is Brian Albert's sister-in-law. So that's true. She does have those direct family ties as well. So they're not gonna hurt each other. They're gonna circle the wagons. They're gonna make sure that no one goes down. And if they get their story straight, they shouldn't have to worry about going down because they got the DAs on their side and the police doing their botched investigation are on their side as well. Lanky like walk the plank. Okay, thanks. All right, next we have, moving on to number 49, Jen McCabe's obsession that night with John O'Keefe's whereabouts. Think about how many times she's wanting to know, is John there yet at the house at 34 Fairview, parked behind me? Then there was like a little lull of activity, and that was the time he was actually going up and down the stairs. So sync those two data points up. Consider the fact that Karen would have left that residence around 12:29, 12:30. And then around that time, we also have the startups again of Jen wanting to find out what's going on with John O'Keefe. She kept calling. Why didn't she call Karen? Why is she calling John? It doesn't make any sense. Why is she texting John? It doesn't make any sense. You'd go from one to the other, but it looks like something was done to make it look like something else was happening innocently to make those calls to John. So, and we know that John's Apple Health data showed the flight of stairs movement. So nobody in that house would have seen that. That just doesn't sound credible. It doesn't sound credible at all. And that's why defense should be allowed to use a third-party culprit defense. They absolutely should be. They don't have to prove anybody else did it. They don't have to point the finger at these three like they did in court. All they have to say is like nothing makes sense. The only thing that really makes sense is that something happened in the house or in the backyard. We don't know, and it's very easy for people to circle the wagons and lock horns on their testimony. And what do they have? Nothing but the forensic digital evidence to contradict that. But that is very powerful, and it does show that something else happened there, and their testimony is not credible. That's the bottom line. Okay, next we have number 50. Karen's statement that she dropped John O'Keefe off was unchallenged in direct evidence. So nobody can actually say that did not happen. Just because they didn't see it doesn't mean it didn't happen. And if he's going up and down stairs, that's another thing that makes Karen's testimony look credible and come across as legitimate. So they don't have anybody that can say, no, I saw the vehicle the whole time. He never got out of the car, or he got out of the car and he just stood there while she went all the way up to the second house past 34 Fairview, and then slams it in reverse and guns it and goes a reckless speed in reverse that no one would absolutely do that if they were street conditions normal, and then you have them very much iced over and full of snow that way. So it doesn't make any sense. Again, that's another data point for reasonable doubt. Okay, moving on to 51. Karen was the only one that showed concern for John O'Keefe's life that night. Think about it. The people that know him, and Jen McCabe that says she loved him. She brought that out in direct examination from Lally. She said she loved John, known him for years. So compare that statement with how she acted that night. Was she upset? Was she frantic that John was laying there near dead or dead in the snow? Look at her 911 call. Did she say, hurry, my buddy John O'Keefe is dying or dead in the snow. He's a Boston police officer. Hurry, get here. Frantically tell 911 operator, get an ambulance there ASAP. None of that. None of that at all. Sound very calm and collected compared to Karen. Is she trying to do any CPR? Is she trying to do anything to like wake him up, help him out? No, it's Karen. Karen's the only one that acted like she loved John by the way she was trying to desperately help him. You heard her on the tapes from the different calls and the responders there that had their cameras going from the vehicle. There is no way you can say Karen was acting as if she was like happy that that had happened. If you look at her phone calls also to John that night, we'll get to that, but her phone calls also, she acted consistent with somebody who was mad about John just basically leaving their house at the front of the curb and not coming back to report on whether it was worthwhile to go into that gathering or not. Okay, next we have 52. Witnesses inside the house were not questioned thoroughly. This is a big, big problem. Witnesses should be thoroughly questioned. They should be brought down to the police station. They should get their statements on paper. They should be writing it or typing it themselves, followed up by questions written out in a Q&A format by law enforcement officers. That's the best way to get to the truth of the matter. That's the best way to get the witnesses' statements that you can preserve for trial testimony. Some, like the FBI, don't allow witnesses to make statements. They just interview them and then they write up summaries of what was said. And I've seen firsthand how those things are not accurate, how you have one or two FBI agents trying to like jot notes down while the witnesses are there talking, and they miss a lot. And so, because I've sat in on an FBI interview and seen how that happens firsthand, where they miss a whole lot, and then I'm telling them, hey, you didn't put this in your report, you didn't put that in your report, that memorializes a statement. So here, that's the same kind of thing they did with Proctor. They just took statements and jot a few notes down and then put it in a police report. You're going to miss so much at that point. You're going to avoid all the obtaining all the real details that you need to prove a case. So it actually hurts a prosecution. If you can do a sloppy prosecution, you got bias completely drowning in the investigation phase. You're not going to help anybody really find out what the truth is. It's going to put more burden on the defense to try to show what happened with these witnesses, because the prosecution had these witnesses available when the memory was fresh. And what do? They completely drop the ball. So that right there is reasonable doubts. And we'll hear from a defense expert, a retired FBI agent, that does talk about many of these botched procedures by the local law enforcement there on this case. Yeah, Ipsy, you're saying all those interviews should have been on body cam. Apparently, they didn't have body cams there. These cops are making $200,000 to $300,000 a year, from what I'm told. So they can't afford normal routine equipment. It's all going to their salaries. Okay, next we have 53. Inconsistent accounts of when John O'Keefe was last seen alive. We don't have any testimony from those inside the house that are claiming that they have seen John O'Keefe. Karen says that she dropped him off, waited for him to go in the house, and she was the last one supposedly to see him alive, and yet we have him go up and down flights of stairs. So when you combine the lack of thorough questioning, the lack of investigating the inside of the house, the backyard, and not doing the normal protocols for making that house be part of the search, getting a search warrant or asking for consent, it's best for law enforcement officers to ask for consent. They don't have to get a warrant that way. They have a signed consent form that can be signed by the party giving the consent. But they didn't even do that. They didn't have to go to a judge. I believe that Brian Albert would have authorized consent, or maybe he wouldn't have, and he would have said, you have no reason to come search my house, go get a warrant. So either way, they missed out on that opportunity, and that's something that the jury should be noting that as well. It just makes everything that defense is saying look more credible. Okay, next we have 54. Karen's panicked calls to John O'Keefe that night revealed frustration, not knowledge that he was injured or dead. So when you think about all these calls, she's calling him names, she's mad at him, she's very angry, she's been drinking that night. She's in a situation where she's like, how can you just completely go in a house and just completely ghost me like that? She is mad. She's furious. She goes home. He still doesn't call her. He completely ignores her, and she's getting madder and madder and madder. That's not the kind of behavior that somebody who intentionally tried to murder John O'Keefe, left him for dead, dying and or dead, is going to make all those phone calls, because as it turns out, that's exactly what anybody would think that would happen. The prosecutor's going to accuse you of having the motive and the means and the intent to kill John O'Keefe. So it just doesn't make any sense. I'll tell you, she does sound sincere. She does sound like she's had too much to drink, but she does sound sincere and frantically upset with John's treatment of her. And you can tell from the tone of her voice, this is not the first time John doesn't show up. John's whereabouts are not accounted for. And she's just very much not secure in the relationship. And that lack of insecurity, I think, was feeding this type of mindset where she's like, what's really going on? And why am I treated so poorly? So those are she was worried about the relationship. She didn't act like she was glad he's done and gone with. She would just driven off and then say, I don't know anything about it, and never call them if she was really guilty of this. Okay, next we have 55. No one heard of the car crash or any impact that night. There's no revving an engine. There's no tracks indicating that there was some kind of spin out of Karen's car if she would have driven that fast as Trooper Paul is trying to make it out to be. So it's just really one of these deals where the lack of that kind of information and evidence, and there's no digital evidence showing she did this, and we know she left out of there 12:29, 12:30ish. That all seems to line up with Karen Reed and her statement that she did not strike John O'Keefe whatsoever. SG Blues, yeah. Well, how about 100 Reasons Why the Albert should be investigated? Yeah. I can't scroll up to, but somebody wrote Karen doesn't have a violent history, but we know who does. Yeah, apparently defense will bring some folks talk about Brian Albert's aggressiveness, and these are law enforcement officer types. So if that happens, that'll be very, very helpful for the defense. Beep Day, boy, you're saying Karen seems to be very intelligent, and the police seem to be low IQ. May the Force is saying, I can't think of a time when I was around anyone whose BAC was so high, like over 2.0. I avoid out of control or blackout drunk folks. Yeah, I mean, she's out of control driving the car that fast in reverse. She would have hit something. It would have caused a scene, and not just something that John O'Keefe, he would have known about it as well. But think about it. That pickup truck behind her would have seen something. If she would have went way ahead, and the timeline doesn't even add up with Jen McCabe saying that happened around 12:45, close to 12:45. The vehicle was pulled way ahead in front of the house beyond 34 Fairview. So the whole timeline is a complete hot mess for the prosecution. I don't know if there's a question there. Thank you for your support. desire for civil discourse. Brennan insists the ground is frozen solid. 3 liters of blood cannot soak into and miraculously disappear from frozen ground. Yeah, that's it was like 12 degrees at night, and depending on how much the temperature was beforehand, it could affect whether the ground's frozen solid or not. So yeah, there's a lot of blood that he lost that is not accounted for, even if they use those solo cups. Kate, you're saying there's no timeline for that so-called key cycle of reversing, is there? I've not seen any timeline. I think any timeline you're trying to come up with, I would be distrustful of, and I don't trust what Trooper Paul says. Chick 56, thank you. You're saying whether there's Karen or whether you like Karen or not. This was a setup. Yeah, so this is not a likability test. Somebody like myself that's been in crim law many years, decades as well. You know, it's nothing's personal. It's all about business. It's all about proof. And some of the nicest people or some of the nastiest people can always get caught up in something, and you just got to look at the evidence and what can they prove or not prove. So you can believe, like I say, you can believe somebody's guilty even as a prosecutor, but if you can't prove it, what are you going to do? Are you going to go to trial on a case you know you're going to lose, or are you just going to go ahead and dismiss the charges or try to plea bargain to something else? Yeah, Ipsy, you're saying the BAC was no way dependable. The blood was not taken to prove her BAC. Plus, it was not an accredited lab in any way. So I think that should be kept out. And she was also drinking when she got back to John's house. So that timeline that they came up with on what her BAC was, blood alcohol content, is completely unreliable because they don't know how much she had to drink and when and all that kind of stuff back at the house. So trying to extrapolate that and do a retro analysis is not going to be credible at all. Nurse Kimberly from Kansas, you're asking, do I think Bever, and I want to call her judge, give her the respect her position as, do I think the Judge Canoni will allow the retired FBI to testify for the defense? She must do that. Otherwise, it's reversible error. If she doesn't, that's going to be a guaranteed reversible error if there was a conviction. But there's not going to be a conviction. And it's pretty sad you have to have a police officer describe how botched this case is for the government. It's so abundantly clear on its face. Okay, next, moving on to 56. When you look and study the overall behavior of the Alberts and the Caves, it's highly suspicious. There's something else there. There's too many head scratching things. What are they saying? Really? This is what you're trying to have us believe happened with your behavior? It's extremely suspicious. You compare that either the families individually versus Karen's behavior, everything they're doing is suspicious. And what I would say what Karen's doing is not suspicious, it's more acting consistent with what she says happened. So it's going to come down to, are you going to believe all these people propped up that has all these different stories that are internally inconsistent? They don't make any sense. They look suspicious. They come across bad on the jury. And, you compare that with what, and convict somebody based on that kind of information. So then you have the ARCA witnesses. It's just not going to make any sense to any jury. That's why I'm predicting that she's going to be found not guilty of all charges. Okay, next we have the 57, the firefighter statements of Karen saying I hit him were disputed. So we did hear some first responders saying that they heard that, but others said they didn't hear that. So I think that's reasonable doubt right there. There's nothing on any kind of audio tape, videotape taken to the scene that indicated that as well. So this is what the AI one came up with. So it's that is disputed as well. And like I say, even if she would have said something like that, to me, that's not incriminating because she might have been blaming herself uh, if she's thinking, well, wait a minute, I dropped him off. What did have something happen? Like she said in some of her interviews, did he slip and fall and it ran over his foot or something and somebody else come by? Who knows? I mean, there could be any number of scenarios, but there's no intent from the way she's acting to say that she tried to hurt him in any way. She loved him, and I think it's abundantly clear she loved him. So she's not some violent person that was trying to kill him. There's no kind of evidence that's credible to that effect. All right, so next we have the 58 is lack of corroboration for the prosecution's timeline. The prosecution's timeline is completely botched up. They jump around. You've seen how they try to say the strike on John O'Keefe happened around 12:45. Then the whole trial they used that and used Trooper Paul to establish 12:45, and then they show a slide in their closing and try to make it look like it's earlier than that. The problem is when it's earlier than that, it has to be much earlier than that John was hurt because we know that there was movement with his Apple Health device, and we know Karen left around 12:29, 12:30, and we also had those folks that were showing up in the pickup truck. There's 3 folks in the car there waiting for the sister to come out of the house, and she did come out of the house after about 5 minutes. So there's all this movement and eyeballs there in the front yard. So what does it lead you to believe but that John went into a house? So I'm curious to see what this new prosecutor, if they also can work on changing the testimony, but they're really locked in from the first trial. Otherwise, the defense will pounce all over that. Yeah, Sarah Hayes, it was actually 12:36. All right. It was actually 12:36, not 12:38. So that's even more favorable. The 12:36 is for Karen's defense. Okay, Septic Hank, you're back, and you're asking the Eagle Eye McCabe account has so many changes and inconsistencies. She says on 911, recording a response to their questions. He got out of the car. Meanwhile, Ricky Nagel and the girlfriend saw only Karen Reed in the vehicle. Yeah, so I mean, it's just to me pretty obvious that John O'Keefe got out of the vehicle. He wasn't struck because the Nagels were right behind him, behind him and Karen in the vehicle. And although they didn't see John go in the house, it's obviously went in the house because he went up and down flights of stairs. There's no other reason he would go up and down the stairs other than the fact he's in the house at 34 Fairview. Get Moholiday, you're asking when the Commonwealth prosecution doesn't trust the FBI, it must be bad. Well, the FBI also investigated the Commonwealth, and how they handled this investigation. So that goes to show you how much they don't trust the corruption. Coffee Cake, you're saying it would be different if there was a dent in the side of the car, i.e. SUV, as if she didn't see him coming back and then flew across the yard or something. But where the light thing was coming from, you don't get it. Yeah, it doesn't make any sense. It's not what happened. Alessi's vocabulary, you're saying Jen was so calm. Yeah, unusually calm. And the way she kept her back to John. Why isn't she like there bending over, trying to encourage him, saying, "You're going to make it, you're going to be okay," or, being attentive to him in some way? No, not at all. It's like her wheels were spinning for some other reason. So what was that reason? Trying to scroll back up here. Yeah, I can't scroll up. Sorry. There's a question I wanted to take. Phoebe Beach is saying a human body would have crushed a polycarb taillight into 48 pieces. We also have the retired North Carolina Highway Patrol officer that's investigating many of these type of cases. He also can vouch for the fact that polycarb is not busting those kind of pieces from being from hitting a pedestrian. So no way. Okay, you're saying that's correct. No way. Thank you, sir. We're not going to scroll back up. All right, let's go through some the comments now. Jennifer Rank, you're asking, why do I think the prosecution is doubling down on a clear case of reasonable doubt? Do you think that they're now trying to clear their names and prevent civil liability? Why not vacate? I think that, you know, when they come up with an official story and it's involving a police officer, they got to stick to the script, and they'll go down swinging, no matter how much of fools they make of themselves, no matter how much. They don't care if this thing would get reversed on appeal if they got a conviction. So they stick to the script. They're not gonna inflate other people that have connections to power, and that's the way politics works. So unless there's something that blows up in some of these faces of the folks that are in the House, and then they want to cooperate and explain what happened, you know, this is probably going to be the official narrative out of that jurisdiction for many years. But I think eventually the truth will come out. At least from the state actors. But I think the jury's going to definitely pick up on all these things and find Karen Read not guilty. Chloe's mom. Let's see, where did that go? Right now it's not moving. So let's go on to the next one. Collins Knuckles, number 59. Think about Collins Knuckles. He had pictures that we saw presented in court that he posted on, I believe it was Facebook and Instagram, that he had bloody knuckles. All four of his knuckles were bloody. Collins says it happened from falling down. He's catching himself, but it seems sort of odd that you would not have your palms facing down towards the pavement if you were going to fall, trip and fall, hurt yourself that way. So I think that was very, very great for the defense to have that kind of testimony come out, and that kind of evidence to come out as well, that he had bloody knuckles that no doubt were swollen as well. And you know, if he had bloody swollen knuckles, obviously nobody's going to mention he was at the scene. So think about it, the fact that it came out much later that he was actually in the house, right? So the fact is, him not being mentioned worked beautifully because his knuckles could meanwhile heal during that time frame. And you know what? Even if he did have bloody knuckles, I don't think Trooper Proctor, any of these officers would have done anything about it to note that or take photos themselves. Al Dente, you're saying, do I think someone will sing? The stress must be enormous, yet they were born into incestuous corruption. So I'm just going to say that if these witnesses are not telling the truth and they've already had to testify in trial one, I think the media coverage of this thing, the fact that you have cameras filming them live and they got to hold up to scrutiny on cross-examination, I think that that is tremendous pressure. They got lawyers. The lawyers going to try to do everything they can to keep them calm and collected. But yeah, internally they're going to be frantic and panicky, having to go through this gauntlet again. Even more people are covering this case, even more national media. So yeah, it should be a pressure cooker for them, and let's see how they try to bob and weave this next time. Okay, and then next we have number 60. That's the tone of Jen McCabe's 911 call, and that's something I'd probably play in my closing to drive home the point that this is somebody that says they love John. This is what they did when they called 911. And you show all the different inconsistencies, all the things she said and did that don't act as someone that loved John O'Keefe. And I think it's going to help really drive home the point that the only story that makes sense is the one from Karen. These other cast of characters, it's not going to make any sense to convict Karen beyond a reasonable doubt, nor should it. And so the attorneys need to focus on all these inconsistencies, the lack of forensic evidence to connect it. In fact, the strongest, most reliable evidence points to Karen Read not being the party that's responsible for John O'Keefe's death. So with that being said, I'll go ahead and jump on to any other follow-up questions here. If you have any question marks, please use a red emoji. That helps me distinguish your chat among yourselves from any questions for me. Sherry D, you're saying Judge Cannone limited the closing to 1 hour time limit. What if Judge Cannone does the same thing? Yeah, that's 1 hour is not enough. There's so many details that they need to go over. Think about it. If a judge limits the timeline, there's less and less lies and discrepancies and failures of the police investigation that defense can talk about and argue. And keep in mind the prosecution gets to do a rebuttal to the closing of the defense. So they automatically are going to get more time to try to convince a jury that they're on the side of justice. Collins Knuckles, you're saying, why hasn't any more attention been given to Higgins' Jeep? No, he even mentions it parked in the street by the mailbox except Higgins. Yeah, that's another interesting point. And think about it, if Karen's was slamming it in reverse and going so fast and could build up to that speed in slick snow. That's another thing. I just thought of this. How could she even build up to that speed in 62 feet? How she get up to 24 miles an hour in 62 feet on a slick, snowy road that had a curve in it? And then you don't smash into something like that Jeep with a plow behind it? It just makes no sense because it didn't happen. If so, you're asking what would happen if Michael Proctor got on the stand and told the truth? How awful would that be for him? Well, I think it'd be so awful that he's not going to ever go down the road. He wants to get his job back. He's hoping this whole thing blows over. He's going to try to probably do some civil litigation to get reinstated. So, all right, and you're saying there's a man in the snow, Jen McCabe. That's what she said on her 911 call. Words to that effect. Who wanted us to believe that she was in the shock and horror of it? Yeah, I mean, come on. There's no way she sounded like this was something that was traumatic to her. So I just think a jury's going to pick up on that. They should definitely play that for the jury in their closing. Phoebe Beach, you're saying they never thought it would get beyond Karen pleading guilty. Yeah, I think that's why they charged her with secondary murder. They thought that could pressure her to roll over to a lesser charge of manslaughter. Yeah, I think I need to do a segment on the District Attorney Morrissey and his public statement. That is something that really is extremely bizarre, outrageous behavior. Oops, jumping ahead here to other ones. Colleen Bennett's is saying Colin's excuse was totally laughable. Harry's mom, you're saying Higgins was so obsessed with talking about him plowing the driveway. I think he initially hit John with the plow. I mean, maybe John slipped on the ice, fell down, and then he's coming in there and he couldn't get up. He had too much to drink, and then he came in with the plow and then hit him and didn't realize it till he got out. Maybe he didn't realize he hit him or something. I mean, who knows? Anything is possible. The burden's on the prosecution to have it all make sense. And they have not done that, nor will they do that. I don't care how many experts they try to bring in this next time. It's not going to hold up. It's not their whole case is a house of cards. Yeah, I already covered that one. Okay. Trying to scroll down to new comments. Sidney Collins saying that John O'Keefe's injuries are not compatible with being hit by any vehicle. I totally agree with that. Patty B, you're asking, how do I think Karen's own statements will come into play at the next trial? She admits to drinking and then asking if she hit him. She also admits to talking to Turtle Boy. Yeah, I mean, no matter what happened with her and Turtle Boy, I think it's like a bad thing for her to have contact with Turtle Boy. Whatever Turtle Boy wants to do to help her cause. If I was her attorney, I'd say don't have any contact with him. If there's information to be passed, I can talk to his attorneys, but we really want to distance yourself from him. We can't be feeding him information, and explain why it's, it could make you look unlikable to a jury, and you don't want to risk that. So, I mean, you're getting a lot of PR from him. So if I was going to allow a client to do that, there can be comments made about it that make her look very unlikable. And so I just think it's a very high risk with really no reward. So, but do I think it's maybe recoverable from what she said so far in the other main news coverage that we've seen? I think I think it's explainable and recoverable. It may put more pressure on the defense to put her on the stand, but in any event. Ipsy, you're saying, for you understand the communication between Karen and Turtle Boy ceased. I hope it has. I really hope it has. Yeah. Jane Brown, you're saying, I understand what people are saying about her talking about. It doesn't matter what Karen says. John O'Keefe was not hit by a car. Yeah. No matter what she says, this makes her unlikable or seem callous, cold, indifferent to John O'Keefe's death. Whatever kind of message they have between her and Turtle Boy, it's not going to be proof that she hit him. And like I say, I don't think you're going to find her saying, "Yeah, I hit him and I'm trying to get away with it. So far, it's working great. We got a hung jury." There's not going to be some kind of stupid, incriminating comment like that. So, um, if it is something about going after the McAlberts and, hey, that's great that you went to see here at the sports stadium and challenged her and stuff. That's not going to be something that is going to indicate she's guilty of striking John O'Keefe with her car. It's just not. It's just not going to matter. But the prosecution, because they don't have any direct physical evidence that ties her to John's injuries, that's why it's more of a smear campaign. So that's another indicator the prosecution knows they got a loser case, is that they're trying to smear Karen as much as they can. They're trying to get behind every statement she's ever made to try to make the narrative comment that she's guilty, and that's why she's acting that way. But it's that desperation should not carry the day when you got the forensic evidence and all the other absolutely strange, bizarre behavior from the people in the house. Septic Hank covers it pretty well. Dr. Rentschler and Dr. Wolf have worked with the Army, NHL, FBI. They're as highly regarded as can be. They were hired by the feds, only pay logistics to be in court. Their expertise and conclusions are indisputable. That's the way I'd look at it. And I think a jury will too, no matter what the prosecution tries to throw up. Nobody's going to have those kind of credentials, in my opinion. Darcy, look at John's autopsy photos. He was beaten up at Fairview. That's what it looks like. He was beaten up and attacked. It was not an object like a vehicle, a bulky object that's made of plastic parts, thin sheet metal. That's not what hit him. Both his eyes are all blacked out. He got beat really bad, enough to kill him, along with a cold. Stella Bill, you're asking how can there be any faith in a jury that the attorneys are allowed to voir dire directly? I think they can do some voir dire. I'm hoping the judge will allow them to do some at least. But because if she controls it all, yeah, you're not gonna have a chance of getting a fair jury, and there's more of a chance you're gonna have a hung jury, as opposed to allowing the attorneys to do their thing. Check 56, you're saying it was said injury is consistent with something like a baseball bat, something very, very much a blunt object. I agree with that. Yeah, none of the medical folks that I've seen make comments on this channel have said anything about these injuries are consistent with what the prosecution's theory is. None. Law and Lit 87, 827, you're saying, isn't it a big deal that the medical examiner said the cause of death was undetermined? Yeah, that is a big thing. I mean, it's something that the prosecution is very upset about. They want to have the medical examiner in their hip pocket to be able to say, yeah, this is homicide. This is consistent with a motor vehicle strike, but it's not, and she didn't say it. And that's reasonable doubt right there. That alone is reasonable doubt. You throw on all these other factors, it's a massive, massive crushing defeat for the prosecution, all these reasonable doubts. Dr. Monk's study, you're saying he was beaten. His brother Paul was at the hospital and said John looked like he went 5 rounds with Mike Tyson, who was a former pro boxer. So yeah, that's what it looks like, other than the dog bites. And I will say the strike on the back of the head does not look like a fist. It looks like some object that would be consistent with something like a bat or some kind of metal object being used to strike somebody in the back of the head to knock them out. Psychology 9, you're saying, oops. Jury instructions need to be extremely clear and understandable to any educational level. Yeah, these jury instructions, I remember listening to some of them, and I was thinking, wow, these things are like a convoluted mess of sorts. And obviously, we had Alan Jackson complain us about some of them, but yeah, it's really not very much due process centric there in Massachusetts, the way the courts operate. It's very disappointing to see that here in America. Renew my faith is saying, how can they charge her if the cause of death is undetermined? Well, that doesn't prevent the district attorneys from coming up with their own conclusions. So I think that this does create reasonable doubt. It's very frustrating from this prosecution standpoint to not have the medical examiner in alignment with them. So yeah, they know that alone is reasonable doubt, but they're going forward anyway. Get Mohali, you're saying cause of death is different than manner of death. We need to listen to what words are used. Yeah, so the cause of death was the blunt force trauma to the back of the head and the hypothermia. In what particular order and percentage, we don't know. That wasn't specified in the report. But you compare that to the manner of death. So, what caused the blunt force trauma to the back of the head? That's just something that was undetermined. The medical examiner did not find that, despite the law enforcement officer telling her the facts, she did not find that this was consistent with a vehicle strike. And so, yeah, that's very helpful to defense. Huge reasonable doubt just there alone. Phoebe Beach, you're asking, did I see Jackson demonstrating a pirouette when cross-examining the Commonwealth accident guy? Priceless. Yeah, I do think that what they should, I have had an idea of that for the next trial as well. So think I'm going to save that for right now. But having different witnesses demonstrate what they're talking about is something that I find at times very helpful in criminal trials. Here we have North Carolina officer saying, according to Trooper Paul, she was traveling 24 miles an hour and traveling 62 feet. If she traveled 62 feet, she would have hit the house. Her tires were spinning, and she's not educated enough to know. He's not educated enough to know. Yeah, so she would have, hit a curb at least and caused damage to her rims. She would have hit the mailbox. She would have hit the Jeep that was out front with a snowplow. So yeah, there's been massive damage from her hitting things. I think it's fair to say. So thank you, sir. All right, I think with that, I'm gonna ask cover one more question or comment, and Okay, officer, officer, let's see, sorry. Thank you, officer. If you want to give me a call, my number is on this channel. If you go to my channel main page, you'll see. And yeah, if I can figure out a way, the technical side of it, how to get you on the panel, let's hash this out, talk about it. Look forward to it. Hopefully, we can make this happen. And so with that, thank you. Let's see your name correctly, Kezchick56. Thank you all for supporting justice. I'm trying to give you as fair and balanced as I can to talk about these issues. So thank you much, and appreciate your questions and this cause for justice. That's justice not just for Karen Read, but also to the O'Keefe family. So with that, you all have a safe week. I'll do more coverage on covering some of these the remaining 60, and there's other issues to cover as well. And also have not forgotten about the Adelson case. So that's coming up down the road here as well. So more coverage on that to follow as well. So y'all have a great one. Take care.